Have you ever looked at a legal document and just wondered, what does this really mean? Well, today, we're diving into a situation that's way more common than you'd think. A real puzzle for property owners. Is that paper you signed an outright sale, or is it secretly a loan? And trust me, getting it wrong can have some massive consequences.
So picture this. You need some cash, right? You sign a document that says sale deed right at the top, but buried in there, there's a clause that lets you buy your property back down the line. So what just happened? Did you actually sell your home? Or did you just take out a loan using your house as security? That's the million-dollar question we're going to unpack right now. All right. To get to the bottom of this, we need to understand two legal concepts. Now, they look almost identical on the surface, but in the eyes of the law, they are worlds apart. Let's break them down. First up, we've got something called a mortgage by conditional sale. Now, the key word here is ostensible. It's a fancy way of saying it looks like a sale. It pretends to be a sale, but it's not. The real intention, the whole point of this document, is to secure a loan. You're not actually selling your property, you're just putting it up as collateral. And then on the other hand, you've got a sale with an option to repurchase. This one is pretty much exactly what it sounds like. It's a real, absolute, no-kidding sale. You're transferring ownership completely. But the buyer, in a separate, independent deal, gives you the option to buy it back later. This is a genuine sale from the get-go.
Okay, this chart right here makes the difference so clear. Just look at the purpose. One's for security, the other is an outright sale. And the title to the property? In a mortgage, you're still the owner. In a sale, that title passes to the buyer immediately. But, and this is the most critical part, the real telltale sign, it's the clause. In a mortgage, that buyback condition is right there, in the same document. In a genuine sale, it's a completely separate agreement. You gotta remember that.
So if these documents can be so confusing, how does the legal system possibly figure out what really happened? Well, turns out the courts have a very clear method for cutting through all the confusing language and finding the actual truth.
So how do the courts decide? It all comes down to one single powerful principle, a simple idea: intention. Above everything else, what matters is the true intention of the people who sign the paper. Not the title, not the label on the front, but what they actually meant to do.
And hey, don't just take my word for it. The Supreme Court of India made this crystal clear. In this huge case, they said, you can't just look at what the document is called, you have to read the entire thing, understand its substance, and figure out the real purpose. A label like sale deed means absolutely nothing if the contents inside are screaming mortgage.
So how do they actually determine that intention?
Well, they use what we can call the one document test. Let's just walk through this. First, the court looks at the clause about the sale and the clause about buying it back. Then they ask the big question, are both of those conditions in the same single document? If the answer is yes, then boom, the law automatically presumes it's a mortgage. And that means the other person, the one claiming it was a real sale, has a really tough job ahead of them to prove it.
And this isn't some old, dusty law. It's being reinforced all the time. Just recently, in 2024, the Supreme Court basically said that courts should always lean towards protecting borrowers. Their default position is to see these deals for what they usually are, a way to get a loan, not a way to lose your property for good. The law is really designed to protect your right to get your property back.
So we know intention is king, but for any property deal to be legally official, it needs one final official step: registration. And this is where things get a little weird, because of a concept called retrospective effect. This timeline just illustrates it perfectly. So let's say you sign the deed on January 15th. But, life happens, and you don't get around to officially registering it with the government until March 10th. So when did the property title actually transfer? You might think it's March 10th, but nope. The law says it operates from the date of execution. So legally, that transfer happened all the way back on January 15th. The registration is just the final step that makes it all official, going all the way back to the day it was signed. All right, we've covered the definitions, the court tests, the legal stuff. So, what's the big takeaway from all this? What's the one thing you absolutely have to remember?
Here it is, your cheat sheet for solving this puzzle every single time. If that condition to buy back is in the same document, you should be thinking mortgage. If it's in a separate agreement, think sale. And never, ever, ever trust the title of the document. Always remember that the court is going to hunt for the true intention. And, at its heart, the law is on the side of the property owner, protecting their right to get their property back from a loan.
So I'll leave you with this thought. The next time you're faced with a property deed, where are you going to look first? Are you going to get fooled by the label on the cover? Or are you going to dig a little deeper and find the true story that's written inside its clauses?
Because knowing the answer to that question, well, it makes all the difference in the world.